Hello there. So this is the first, I guess, Italianes Law School Edition UBE law recording that I'm going to do. And for anyone out there who is an auditory learner who's realized that, you know, it's not just about writing out their outlines or condensing them, because that's not how you learn. This is for you. And so I'm going to read out the law, and I hope that it helps you, as I hope that it's going to help me. So this is real property. Estates and land. Fee simple absolute. 100% ownership forever. Life estate. Rights and control for life, no waste. Reversion. Interest goes back to grantor. Interest and taxes. Life tenant must pay interest and taxes. Remainder. Interest after a life estate. Contingent remainder. Something needs to happen for property to pass. Vested remainder. Subject to open partial. Class of people must be alive. Vested remainder subject to total divestment. Person's interest can be wiped out. Fee simple determinable, so long as. Possibility of reverter. Reverts to grantor if condition not met. Fee simple subject to condition subsequent. If future event occurs, grantor has right of reentry. But if. Right of reentry. Grantor must act to get land back. Rules against perpetuities. Interest must vest within 21 years of life and being. Concurrent estates. Joint tenancy. Right of survivorship trumps a will. Conveyance severs a joint tenancy and makes it into a tenancy in common. Tenancy in common. No right of survivorship. Tenancy by the entirety. Joint tenancy between married people. Right of survivorship. No conveyance without consent. Severed by divorce. Partition. Court divides property in two. Granted unless not practical. Contribution with taxes and mortgage. A co-tenant may seek contribution. The sole possessor can only recover the amount that exceeds market value. Contribution rent. The out-of-possession co-tenant may share in rent or profits, not from tenant in possession unless damaging property. Landlord-tenant relationships. Periodic tenancy. Start date with a period of time. Renews unless termination date. Notice required to terminate. Tenancy of years. Start date with an end date. No notice required. Tenancy at will. Terminable at will. Reasonable amount of time to terminate. Tenancy at sufferance. Holdover tenant. Terminates by leaving or eviction. Landlord duties. Actual possession. Duty for basic repairs. Warranty of habitability. Warranty of quiet enjoyment. Tenant duties. Duty to pay rent. Cannot commit waste. If tenant does not pay rent, abandons property, landlord can sue tenants for damages or treat it as a surrender. Assignment and sublease. Assignment. The landlord can sue the assigner and assignee if the assignee does not pay rent. Assign the rest of the lease term. New tenants primarily liable. The tenant grants all the time remaining on the lease to the assignee. Original tenant secondarily liable unless novation. Sublease. Landlord cannot sue the subleasee for non-payment of rent. Tenant grants only part of the time of the lease and still has interest in the property, meaning they give away a portion of their lease. The original tenant is still liable unless there is a novation, because there is no privity between the landlord and the sublease. Covenant against assignment or sublease. Strictly construed. Fair Housing Act. Federal law prohibits discrimination in sale and rental based on race, color, religion, sex, disability, family status, and pregnancy. Fixtures. The chattel affixed to a property. Removal would cause damage. Conflict of laws. Law of the state where property is located will apply. Exceptions. Choice of law clause, collateral issues under local law. Rights and land. Easement. The right to use someone else's land. Creation of an easement. In writing, by prescription, open, notorious, continuous, hostile, like adverse possession. By implication, prior use. By necessity. An easement, non-possessory right to use the property of another. Will last forever unless terminated. Easement holder does not own land, only has right to use it. Can be terminated by agreement, time, merger, abandonment, not use enough. Easement chart. Type. Creation, requirements, applies, and memory. Express easement is granted, is created by writing to satisfy the statute of frauds. The requirements are clear intent to create it, and it applies to how the parties agree to it. And how to remember this is we signed for it. Implication easement. It is created by a prior use. The requirements are prior common ownership, the use is continuous, apparent, necessary, and it applies to how it was used before it was split. We can memorize this by remembering the words used it before or used it after. Easement by necessity. It is created when it arises when a land is severed or a land is locked. The requirements are the prior common ownership, strict necessity at severance. It applies when the land is landlocked or after a split. We can memorize this by remembering that if there's no access to like a road, the law gives you one. Easement by prescription. It is created by long-term or adverse use. So this is like adverse possession. It has to be open, notorious, continuous, actual, and hostile for the statutory period. It applies when someone uses another person's land without their permission for long enough. We can memorize it by remembering I used it long enough, so now it is mine. Easement by estoppel. The owner allows the use, the user relies on it, and the owner now wants to revoke this. The requirements are that there was permission, there was reliance, and then there was a detriment. It applies when someone says, sure, You can use this, but then they want to remove it, even though the user spent money on it. And how we can memorize it is by remembering that, someone can't take it back because I relied on it. Easement by appurtenant. This is a category, not a creation method. This is just to explain that the dormant estate benefits and the servient estate is burden. There is a right of way, there's a shared, utility or something is shared, and this attaches to the land. Easement in gross, it is created expressly. It benefits the person, not the land. It can apply to a utility company or pipeline. Again, we can remember in gross means that it is for a person, not a parcel. How an easement can be terminated? By merger. The dominant and servient estate now become one under a common ownership. The requirements for this are that there be complete unity of title. This will extinguish the easement. It applies when an owner buys both parcels. We can memorize this when one person owns both, then the easement is gone. Easement can be terminated by abandonment. Means the holder, they intend to abandon it. There are clear activities, no other easement. It applies when someone may block a path or build something over it. So we can memorize this by remembering that there's action and intent, and so the easement is gone. An easement can be terminated by release. The holder signs written release. It satisfies the statute of fraud, and they express surrender of the easement, and they sign it away. Termination prescription. An easement can be terminated by prescription. Servient owner blocks easement for statutory period. The requirements are for it to be hostile, open, continuous. This applies when someone builds a fence, blocks a path, maybe 20 years go by. This is like a reverse prescription. A covenant. A covenant restricts how the owner can use his or her land, meaning they can or can't do something. This is a promise for a promise. Always created by a writing, generally lasts forever. A covenant runs with the land if it is in writing, because then the statute of frauds is satisfied. There is intent. Covenant binds future successors. There is notice, the record notice to the person the covenant is enforced against. There is privity, which is either horizontal or vertical, and it touches and concerns the land, either makes the land more valuable or useful. Horizontal privity. The original owners had a shared interest in the land, landlord-tenant, or grantor-grantee. Example, the developer sells a lot, it includes shared road maintenance, an agreement in the deed, or a landlord owner sells a portion of a property with a restriction on future construction to preserve the view. Vertical privity is between a new successor. So for the burden to run, a successor's interest must have received the entire duration, no interest held by covenant at the time he made the covenant. So we have Lot A and Lot B. Lot A is a dominant estate. Lot B is a servient estate. There is horizontal privity between those two. and between A, who owns lot A, and B, who owns lot B. That is the horizontal privity that goes across. But then if A sells to C and B sells to D, that is the vertical privity. D must receive entire durational estate that the original covenantor, B, had when he made the promise. For example, if B had fee simple, D must get fee simple. A lease is not enough. The covenant won't bind D not to build a fence if he only gets a lease, but the lease conditions might still bind him not to do that. Again, for the benefit to run, any succeeding possessory interest has to be the same. Real covenants bind successors when pint, meaning there is privity, there is intent, there is notice, and it touches and concerns the land. For example, keep fence and driveway in good repair or use pool. But if you were to say they use the pool, there's not a covenant there. It doesn't touch the land. Equitable servitude looks like a restrictive covenant. There is a writing or a common scheme. There is intent. It touches and concerns the land. There is notice. No privity requirements. The remedy here, though, are not monetary damages, but rather an injunction. A license is a right to enter land. It is revocable by a grantor unless coupled with interest. Profit, it is a right to enter land and take something from it. A taking. The government takes private property for public use, requires just compensation. Water rights, reasonable use of water, amount of water, means to alter the flow of rain or snow. The crops go with property unless the tenant had right to harvest. Support rights. The law protects your undeveloped land if your neighbor's excavation causes your land to collapse, because your land, in its natural state, never contributed to the risk. Adjoining undeveloped property, there's strict liability for damage. Adjoining developed property, strict liability if damage would have happened anyway. If extra weight of building caused a collapse, no strict liability. Plaintiff must prove negligence. Buildings create an additional risk. Strict liability if damage would have happened anyway. Negligence. Buildings create an additional risk, so neighbor not automatically liable for weight he did not create. Nuisance. Private unreasonable interference with use and enjoyment. Reasonable person standard. Public affects public at large. Private plaintiff must prove special damages. Common interest formed community. You need a declaration, an association, a board, a developer. The developer gives power to the association 2 or 3 years. And then with a 2 out of 3rd vote to terminate developer. The developer cannot change declaration unless stated. The board acts on behalf of an association to manage it. Board rules must be reasonably related to further a legitimate purpose of the association. Powers of the community. Levy assessment and fees. Manage and improve common areas. Create rules, impose fines, conduct reasonable inspections, revoke privileges. Litigate as the association. Duties of the community. Treat members fairly. Ordinary care in managing property and finances. Access to info. Member has burden to prove breach. Board member duties. Act in good faith. Standard of care is an ordinary director of a common interest. Board members not jointly or severally liable. Contracts in real estate. To convey title, you need 1, real estate contract, and 2, a deed. To satisfy the statute of frauds, the contract must be in writing or part performance. 2 out of 3 done. 1, payment, 2, possession, or 3, valuable improvements. Real estate contract terms. You need the price, you need the parties, you need the description, the conditions, and signed by the party to be charged. Equitable conversion. Transfer of equitable title, but not legal title, meaning the risk of loss shifts to the buyer. Legal title. Seller does not need legal title on day of signing. Marketable title. Implied covenant to convey title free of encumbrances. Time. Not of the essence unless stated. Merger. At closing, the contract merges into the deed, can no longer sue under the contract. Seller's duty to disclose. Material defects that cannot be seen by the buyer. Mortgages. Private money mortgage. Money used to purchase the property always gets privity. Redemption. Always gets priority. Redemption. Pays off debt to prevent foreclosure. Equitable right of redemption. Time that mortgagee has to find money to pay off mortgage to prevent foreclosure. Time from notice to sell can never be waived. Statutory redemption. Period of time after foreclosure sale, not automatic. Lien theory. Bank holds title, owner has equitable interest, owner cannot sell. Joint tenancy. Under the lien theory, the mortgage does not sever this because the mortgage is only a lien, a security interest, not title transferred. But under a title theory, the mortgage severs a joint tenancy into tenancy in common. A mortgage transfers legal title to the lender until the loan is paid off. The moment a joint tenant mortgages their share, they transfer title to a third party, breaching unity of title. Because a joint tenancy requires 4 entities: a title, time, interest, possession. If any unity is destroyed, automatic severance makes the joint tenancy into a tenancy in common. The rule is, under lien theory, a mortgage is only a lien and does not destroy any unity, so the joint tenancy is not severed. But under title theory, a mortgage transfers legal title to the lender, destroying the unity of title, severing joint tenancy and making it into tenancy in common. Subject to mortgage. The original owner is liable for payment, but bank can foreclose on new owner. Deed in lieu of foreclosure. You sign the deed to the bank and you skip foreclosure proceedings. Mortgages taken after are wiped out. Must be given notice, joined to suit. Mortgages taken before stay. Buyer takes subject to. Deficiency judgment. You collect the remaining money not recovered by foreclosure sale. Installment land contract. No title until all payments made. Seller can take back after default. Legal title to property. Gives a person a legal right to 1, possess property, 2, control it, 3, use it, 4, transfer it, 5, mortgage it, 6, pass it through will or intestacy. You prove legal title through a valid deed or other recognized document of title. A deed is a written instrument used to transfer legal title to real property. If deed is valid and property delivered, grantee becomes legal title holder. A deed transfers legal title when it is 1, executed, 2, delivered. with present intent to transfer. 3, accepted. If any of the element is missing, it doesn't pass. A deed requires these elements. 1, to be in writing to satisfy statute of frauds. 2, the grantor signature. An agent can sign on behalf of a principal if principal gives authority in writing. 3, identification of grantor and grantee. 4, description of the property. 5, words of intent to transfer title. I grant, I convey. Delivery of deed. Handing over the physical deed is not necessary. You can place it in an escrow or record it. What matters is the intent. That presumes transfer, so no physical transfer needed. Installment land contract, there is no title until all payments are made. Seller can take back after default. Deed transfers legal title on day of closing. Present warranties. 1, Sason, a promise I own the property. I promise I own the property. 2, right to convey. I have legal title. 3, covenant against encumbrances. If these are breached, then they are breached at the time of closing. Future warranties. To quiet enjoyment. Nothing will happen. 2, a warranty. No future claims. I will defend you if it did. And 3, these last forever. Further assurances. I will fix any problem if they come up. General warranty deed. A promise for all 6 warranties since property was developed or created. Special warranty deed. Promise for all 6 warranties since seller had title. We should assume that on the MBE questions, when they say warranty deed, they mean general. It will specify if it's a special warranty. Quitclaim deed, no promise regarding title. Formalities at closing. It needs to be in writing to satisfy statute of frauds. 2, there needs to be a delivery of the deed. Intent of the seller to give up control. 3, acceptance of the deed, presumed unless rejected. 4, a merger, the contract and the deed merge at closing. And 5, description of property, reasonable, definitive. If there is no will, the property passes according to interstate laws, and an estate will pay off liens. In order for an individual to acquire title through adverse possession, they need to prove these things. That their use of the land that's not theirs was continuous for the period of time that the statute requires it. That it was actual, so they were on the land. That it was open and notorious. Everyone could see that they were on the land. It was hostile. They did it without an owner's consent. And it was exclusive. They didn't share with the owner the use of this land. And the taking doctrine is when the intentional transfer of the use from one person to another. They take the time that they've used to adversely possess the land and give it to someone else so that they will come up with the time needed. Who gets to draft documents? A non-attorney can do it, but they cannot give legal advice. The equal dignity rule. An agent may sign on behalf of a grantor, but must have written permission. The exceptions are an officer of a court, signing agent, notice statute. Subsequent purchases for value without notice. First bona fide purchaser prevails. Race statute. First person to record wins. Shelter rule. One who takes from a bona fide purchaser prevails against anyone the transfer bona fide purchaser would have prevailed against. Wild deed. A recorded deed outside of the chain of title. After acquired title. If grantor acquires title after closing, title will pass automatically to grantee.